afternoon to everyone. I am really delighted and honored to be here and to see so many familiar faces. I want to begin by positioning myself and to let you know that I began working, as you heard in the introduction, as a teacher. I taught geography at my alma mater, the Antigua Grammar School, and I'm happy to see one of my old schoolmates, we call E.B. Joseph, who's here, welcome. And I also taught at the Antigua Teacher Training College. But the interesting thing is that within 2 years of my teaching career, I was retired in the public interest, thereby making me one of the youngest retirees ever in the history of Antigua and Barbuda at the age of 23. This was done, of course, as you've heard, by an apparatus that retained all the features of colonialism. And so let me begin by just giving a brief historical background to Antigua and Barbuda. Antigua was first colonized by the English in 1632. And in that year, the British not only colonized Antigua, but a year before, year after, in that general period, all the other islands in the Caribbean were similarly colonized. I want to look at the history in a number of different parts this evening. I've divided the reflections into 3 parts. Firstly, I look at the dominant discourse, what I refer to as the dominant discourse or the colonial discourse. I examine some of the instances of resistance to the colonial inscription, which had morphed into a form of political capitalism with a profoundly undemocratic ethos. Finally, I explore the possibility of rethinking our Caribbean democracy towards a more emancipatory outcome. Throughout these reflections, I have used the concept of the discourse to describe the relationships of power in the colonial and post-colonial period. Now, as I was indicating, the English, having colonized Antigua in 1632, the island was organized around sugar plantations using the labor of enslaved Africans. After slavery was abolished, laws and rules were put in place intended to maintain the dominance of the plantation owners and the denial of land rights and political rights to the majority African population. Now, the colonial inscription on public order was evident in the laws that were put in place after emancipation in Antigua. One such law, which was passed in 1838, made it an offense to watch and beset the premises of the former slave masters. Well, this law was resurrected when a dozen members of the Antigua Union of Teachers decided to peacefully picket the Ministry of Education in Antigua in 1978 in furtherance of a trade dispute. Well, we were charged with, guess what? Watching and besetting the office of the Minister of Education. Well, after being exonerated by the courts, we were then retired in the public interest as a form of summary dismissal, which was previously the preserve of the colonial governor. Now, I begin here because in many ways, this episode was for me the start of a journey of praxis in the post-colonial society of Antigua and Barbuda. And so in these reflections, I shall attempt to show how despite formal constitutional decolonization, colonial norms and forms have persisted. And the state power, which was previously used by the colonials to maintain their relationship with the colonized people, after the granting of political independence, instead of an interpretation with a liberating interpretation, the rulers, those who gained power, instead sought to restrict freedom rather than to expand and to increase the boundaries of freedom. Now, what we experienced as teachers was the executive arm of the government seeking to transplant that power to dismiss at pleasure from the British appointed governor to the local cabinet. In identifying the dominant discourse, I also identify the discourse of resistance. Now, the dominant discourse is a perception of reality based on constitutional formalism with a fundamentally undemocratic ethos. And by that, I'm speaking of constitutional formalism in that you will find that in many of these islands, we have all the bells and whistles of what would be described as a constitutional democracy. You have the parliament, you have the courts, you have all of these normal systems that function in a constitutional democracy. But underlying that, where the real meaning lies, that's where I want to go. And so I'm tracing it from the original period of colonialism to see how this comes all the way through to the present time. So historically, the dominant discourse has provided the ideological and moral arguments to justify the suppression of freedom. It elevated the right of property over human dignity. The planter class maintained their dominance not only by force, but by shaping perceptions, beliefs, and behaviors. And so the reality has always been that with the dominant discourse, you get people to buy into that perception of reality, that understanding of power relations, that understanding of what is considered to be justifiable, what's considered to be reasonable. Those concepts are all shaped by those who are responsible for the state institutions and who bring that definition of reality, which is embodied by a lot of the people in any society, which means that apart from needing to use force to maintain positions of authority and dominance, you use other means so that people actually accept their status, which was the case in many of the countries of the Caribbean. And so, on the other hand, of course, you have the discourse of resistance. And the discourse of resistance manifested itself in many forms, such as the demand for freedom, the demand for freedom of expression, freedom of assembly, and the right to human dignity. In several instances, the outcomes were intense and violent, which I refer to as social reckoning, where colonial institutions were challenged and matters were brought to the forefront of public consciousness. Now, the impact of social reckoning is what led eventually to the Slavery Abolition Act. This was passed by the British Parliament in 1833. It was officially described as an act for the abolition of slavery throughout the British colonies, for promoting the industry of the manumitted slaves and for compensating the persons hitherto entitled to the services of such slaves. So herein I'm saying the act recognized the plantation owners' rights of property in the slaves and made provision for them to be compensated for their loss of property. So the act elevated the right not to be deprived of property over the moral right to be free from bondage. The discourse of resistance had won the war, but the spoils went to the discourse of colonialism, the dominant discourse, the discourse that created the facade that everything was fine and the act actually brought real freedom, which it didn't. Accordingly, the transformation in legal relations in recognizing the human status of the African did not create a change in social relations. The social inequalities that had existed prior to emancipation continued, with all the inherent tensions that had given rise to public disorder in the previous era. And so what we have is the two contending discourses, the discourse of resistance and the dominant discourse, constant contestation, and resulting in uprisings, in riots, in forms of resistance that were manifest in various forms. So in this period leading up to the attainment of self-government, the British introduced a system of crown colony government, and that was introduced after what is known as the Morant Bay Rebellion. The Morant Bay Rebellion took place in 1865. But before 1865, in 1858 in Antigua, you also had an uprising. And in Barbados, you had uprisings. And throughout these islands, you had these uprisings. And so the British decided that they would introduce a form of crown colony government and remove all elected assemblies, which at that time were dominated by the planters. So with all legislative and executive power vested in the governor, constitutional principles were forged in a profoundly undemocratic authoritarian culture. This period was characterized by the abolition of representative assemblies and the emergence of trade unions and political parties. The cycle of fear and hostility exploded into regular outbreaks of public disorder. These outbreaks led to more fear and more laws to prevent public assembly and expression. The public order disturbances led to the appointment of at least 4 royal commissions of inquiry. Now, land was one of the issues at the center of the cry for freedom and representational government. And one of the commissions was the Norman Commission in 1897. And the representatives of the laborers, the artisans, and all the taxpayers complained that though they were willing to buy land, they could find no owner willing to sell. In addition to the fact that dependence on the plantation limited their freedom to exercise their civil liberties, there was a major feature where land was considered the critical factor in this fight for self-government. Yet, none of the independence constitutions established a presumptive right to own land by those who had been economically disenfranchised and socially marginalized. In all the Commonwealth Caribbean constitutions, there is the enshrined protection from deprivation of property, including land. This is a standard clause in any Bill of Rights, and its inclusion is in keeping with international human rights norms. However, one of the main demands of the movement for self-government was for access to land. And so in retrospect, one can say it would have been in keeping with the demands emanating from the discourse of resistance for the addition of a separate clause which guaranteed access to land subject to reasonably justifiable limitations. And so what I'm saying here is that, yes, the right not to have your land taken away from you is a standard in any Bill of Rights. However, given the very peculiar circumstances under which we gained our independence and the cry and the thrust of the discourse of resistance was land. Yet when the time came for the Constitution to be framed, there was no statement which gave to those who were demanding land and out of whose struggle the constitutions and independence came, that presumptive right to land. Now, the question of land ownership, however, featured significantly at the pre-independence conference for Antigua and Barbuda held at Lancaster House in London in 1980. In addition to the British delegation, There were delegations representing the government of Antigua and Barbuda, the official opposition of Antigua and Barbuda, and there was the Barbuda delegation. Now, I must tell you, Barbuda is this small island off the coast of Antigua, and together they form the nation of Antigua and Barbuda. But historically, the Barbudans have had a very close affinity with their land. And they have a unique system of landholding where the land is owned by everyone in common. And this has been the case for as long as Barbudans have occupied that island. And so this is another source of great tension. And so at that conference, the Barbudans insisted that they would not give up their land. And in the end, they did not sign off on the final independence document because it did not include that particular right. What happened was a very British type of settlement where they shook hands and said, okay, we won't put it in the document, but we won't disturb it. So we'll live with that. And so for many years, it remained that way. Successive administrations respected that right to own the land in common. In 2007, during the period of our administration, we passed the Barbuda Land Act, which formalized by statute their right to own the land in common. Unfortunately, by 2015, after the table had turned and there was a change, the Barbuda Land Act was abolished. And today, what is happening is that there's an attempt to make Barbuda what would be an island where rich people will be able to buy land, and this will be obviously a matter where the Barbudans will now be disenfranchised of the land that they have historically owned in common. The matter continues to be contentious and is one of those hot button issues that if you get a chance, you might want to Google it or you pay attention and you will see that this remains one of the intense struggles taking place with a very small island, but it's a pretty big issue. Now, the colonial inscription also affected the perception of punishment. So in relation to punishment, the new independence constitutions imported into the Bill of Rights what's known as the Savings Clause. And in the Savings Clause, it says basically that any law that was considered constitutional or legal before the Constitution came into effect, or on the day when the Constitution came into effect, would be deemed to be constitutional. So it could not be challenged. So that meant now that some of the old forms of punishment were saved. They could not be challenged, and to this day cannot be challenged. I'm talking about flogging. I'm talking about whipping. I'm talking about hanging. These were colonial forms of punishment introduced by the English. And interestingly, the English abolished these in 1969, I think it was. And even though the English have abolished it, we in all the Caribbean countries have retained hanging, whipping, flogging, and flogging is done by a whip known as the cat o' nine tails. And that's where you hold the whip with 9 tails with a piece of steel at the end of it, and persons are whipped across their backs. Happily, it hasn't been applied for some time, but it's still on the books, and there's still people who, whenever anything happens in society, they would call for the return of the cat o' nine. So that sense of inhuman punishment cannot be challenged. Another egregious colonial inscription was in relation to the family when we speak of rights. The colonial discourse on family was constructed around the social values of Victorian England. The practical application of the concept, it has been discriminatory, it has been contradictory, with serious gendered and racialized consequences. Under the West Indian slave laws, Christian marriage was forbidden among slaves. This led to a pattern of family formation, including an extended family network and de facto marriages without formal recognition. The women were regarded as wives in a cultural sense, but had no recognized identity and therefore no legal standing in formal succession proceedings. And what we're talking about here is a situation where In many cases, women within the Caribbean context and in that cultural sense, they performed all the normal duties of a matrimonial partner. They were regarded in society as wives. Yet the law continues to deprive such persons of any form of recognition. There's reference, for example, to the term common law wife. But the term common law wife gives you no rights. And so you have a situation where a woman will be the partner of a man for a long time. And he dies. And with his passing, she's entitled to nothing. It has also discriminated against children, where children are described as either legitimate or illegitimate based on the marital status of their parents. And so for a long time, until for the first time in the Caribbean, the government of Michael Manley abolished what were known as the bastardy laws, whereby persons were now regarded, regardless of the marital status of their parents, as legitimate. In Antigua, it was finally abolished in 1983, whereby you no longer had the distinction between legitimate and illegitimate. Now, this colonial discourse, which discriminated against children based on their marital status, they were victimized because they couldn't go to certain schools. Growing up in Antigua, if your parents were not married, there are certain schools you couldn't attend. There are certain jobs you wouldn't be able to get. That was the level of discrimination, and it affected mainly women. Now, this matter came up in a famous Bermudan case, the case of Fisher versus the Minister of Home Affairs. In that case, the Bermudan authorities gave a very narrow definition to the constitutional meaning of child. And they sought to exclude a particular child, but by definition, all children had been excluded by this definition of child. And it reached all the way to the Privy Council. And it was actually a landmark case in terms of how constitutional law ought to be interpreted, which I'll deal with in a few moments. But in a very famous dictum, Lord Wilberforce, in that case, who sat at the Privy Council, he was the one who said that the Constitution must be given a particular type of interpretation. And in such circumstances, child would mean all children, not only those whose parents were married. So that was, again, another major breakthrough in terms of nailing the constitutional inscription which had discriminated against women and discriminated against children. Now, what we see here is a culture of resistance developing against the dominant discourse. And the most complete negation of the colonial discourse was manifested with the emergence of Rastafari. Now, Rastafari emerged in the 1930s in Jamaica. It is one of the few belief systems to have originated in the Caribbean. Rastafari, they revere Haile Selassie as a direct descendant of Solomon and Sheba, and regard his imperial majesty as the second manifestation of the Christ predicted in the book of Revelation. They promote healthy dietary practices and plant-based food known as ital. Now, the question for the court in the case of Franklin Francis against the Attorney General was whether as an indigenous belief system, Rastafari was entitled to constitutional protection, and whether or not Rastafari in that constitutional protection should be able to enjoy their sacrament. Now, I appeared in that case alongside Lord Gifford, Tony Gifford of the English and Jamaican Bar. Now, King Franchi, or Franklin Francis, his government name, he was an elder in the Rastafari organization. And he was charged with possession of cannabis, contrary to the Misuse of Drugs Act. We filed a constitutional motion, among other things, seeking a declaration that Rastafari was a religion and that the inclusion of cannabis in the schedule of controlled drugs under the Act was a violation. Now, we had from the University of the West Indies, Professor Barry Chavans, may he rest in peace. At that time, he was Dean of the Faculty of Social Sciences at the University of the West Indies. He was the principal expert witness. And he was able to give evidence that was very persuasive to the point where the court, for the first time, not only in Antigua, but in the Caribbean, recognized Rastafari as a religion to be not only recognized, but to be entitled to the protection of the Constitution. The implications of that were, one, Rastafari children previously were not allowed to attend certain schools unless they trimmed their locks. And if you had locks and you went to prison, they would hold you and they would just trim it all off. Now, with the recognition of the Constitution, they could claim that right. And happily, that practice has now come to an end. Now, the adherents of Rastafari, they were persecuted, they were criminalized, they're prosecuted, unable to get jobs and that type of thing. And whilst it was a victory in the recognition of the Rastafari as a religion, it was only a partial victory. The court took a very cautious approach to the question of cannabis and said that whilst it's a religion, in the interest of public health and public order, they would not give recognition to cannabis. Well, that was then. But just to show how things have changed, I walk in the streets of Toronto every day, and I'm seeing all sorts of brand names and all sorts of advertisements. In one case, I was walking on the sidewalk, and it's telling me, you know, a joint a day keeps you happy. No, that's today, 2024, in Canada. But I'm saying, just a few years ago, the Rastafari, they were not asking for recreational use. They were asking for recognition as a sacrament, and the courts denied it. Well, today in the Caribbean, many of the legislatures have changed that, and you find that in a handful of countries, the sacramental use is recognized. Now, I want to say that a phenomenon has emerged in the Caribbean, and I focus now on Antigua, which I refer to as political capitalism. Now, a key characteristic of political capitalism, as we look at this shift from colonial control to political capitalism, was that you have patronage as a major feature of the political process, where favors are exchanged for loyalty and support. And to maintain these power relations, it is important to suppress voices of dissent and to create a univocal media environment. And by univocal media environment, I'm speaking of a situation where you pretty much only hear one voice. And I want to speak of 3 cases in Antigua. And by way of preface, let me say that the question of freedom of expression as a human right in Antigua and Barbuda was singled out for special mention by the learned authors of a book, which is a fine textbook, Fundamentals of Caribbean Constitutional Law. Now, they note the standard for determining whether limits on rights can be justified in the public interest, or to protect the rights of others, has emerged primarily from a series of benchmark Eastern Caribbean cases that reached the Privy Council in the 90s and early 2000s, mostly from Antigua and Barbuda. Now, this raises the issue of the role of the Privy Council, the Judicial Committee of the Privy Council, in shaping human rights jurisprudence in the Caribbean and in Antigua in particular. Now, in the 60s and 70s, the Privy Council called upon to adjudicate on many of the issues arising from the constitutions of the newly independent states. They had a highly deferential attitude towards the newly independent parliament. And that's because they come from a tradition where parliament is supreme. And so with that sense of parliamentary supremacy, whenever they approach laws coming from the Caribbean which were challenged, they adopted what was known as the presumption of constitutionality. It was presumed to be constitutional. And what they said, it's a very heavy burden for you to shift that. So once you challenged a law that was passed by one of these parliaments, they would treat it as constitutional, and it was very difficult for you to shift that. Now, this particular approach, it stifled the growth of constitutional law in the Caribbean. And that's because there's an obvious incongruence between parliamentary supremacy and constitutional supremacy. Because in the Caribbean, the Constitution is supreme, not Parliament. So this presumption was applied in the case of Antigua Times versus the Attorney General in 1973. This is one of the early cases that came up to the Privy Council. And the Privy Council took a very backward position, I'm saying. In that case, they actually reversed a decision from the Court of Appeal in the Eastern Caribbean, which had held that a law which required a publisher of any publisher of a newspaper to first obtain permission from the Cabinet Secretary and also to place a bond of a substantial amount of money, they said that's unconstitutional. When it went to the Privy Council said, no, there's nothing wrong with it. It's perfectly constitutional, applying that presumption of constitutionality. But we see how this changes, because what was happening was that in the 70s, the Privy Council continued with that particular approach. And it was manifested in cases, even English cases. For example, there's the famous case of the Sunday Times versus the Attorney General. And that's known as the spy catcher case. That's where this man by the name of Wright, a former spy, he published this book called Spy Catcher. And the Attorney General's office fought against it, the British government fought against it, because they said that it was a dangerous book, that it was exposing secrets which ought not to be exposed. The matter went all the way to the House of Lords, and House of Lords, Privy Council, basically the same thing. Highest court in England called House of Lords, highest court in the Commonwealth called Privy Council. And they ruled that the publication of Spy Catcher was not allowed. It went to the European Court on Human Rights. And the European Court ruled that the House of Lords had ruled in violation of the European Convention on Human Rights. Now, what's the significance of that? The significance of that is that we are now looking at international human rights laws, norms, coming into and influencing laws that are being decided upon for the Caribbean and others. So in the 70s, you had this resistance from the Privy Council and the House of Lords against any conception of interpretation of human rights law where you start with the presumption, not that it's constitutional, but you start with the presumption that the Constitution guarantees a particular right. Because the constitutions are framed in the language that says, no person shall be deprived of his right to freedom of expression unless it can be shown to be reasonably justifiable in a democratic society or reasonably necessary in the interests of public health, public safety, and that type of thing. So we see a shift now taking place where the norms from the European Convention, from the Inter-American Convention on Human Rights, from the Universal Declaration on Human Rights at the United Nations, all of these now begin to influence the interpretation of the Constitution. And that brings me now to the Hector case, because the Hector case now comes up in 1990. Now, by now, the Privy Council has seen the error of its ways, they're shifting, and so when the Hector case comes up, by a quirk, the Court of Appeal in the Caribbean, they said to Hector, you have no case, it goes to the Privy Council. The Privy Council rules in favor of Hector. But who was Hector? Hector was a journalist and the editor of the opposition-aligned outlet newspaper. And he published an article. And as a result of that publication, he was charged with publishing a false statement likely to undermine public confidence in the conduct of public affairs. He was sentenced by the magistrate to 6 months in prison. Luckily, a constitutional motion was filed. The matter was fought all the way up to the Privy Council. the Privy Council eventually completely exonerated Hector, again emphasizing the importance of freedom of expression and relying on international human rights norms in order to come to their decision. Now, shortly after Hector, you had the case of Eloy de Freitas. Eloy de Freitas was a civil servant, and every effort was used to silence him. And he had picketed with a number of other persons. And in that peaceful picket, no, he wasn't charged with Washington the besetting this time. But what happened was that they suspended him from his work. And he filed a constitutional motion alleging that his freedom of expression had been infringed. Again, it went all the way to the Privy Council. The Court of Appeal, unfortunately, ruled against him. The Privy Council, using the international norms, found for de Freitas. And after de Freitas, and the third in this trio of cases, is the case of Observer Publications Limited versus the Attorney General. Now, Observer Publications Limited, they wanted to open a radio station. I have to tell you that at this time, what the media environment was in my country. The media environment was one whereby you had one television station run by the government. You had 3 radio stations. One was run by the government. The other was run by the Prime Minister's brother. And the third one was a Christian religious network. Those were the only 3. Well, 2 brothers by the name of Winston and Fergie Derrick, they would not allow the government to refuse them. What the government would normally do is when you apply for a license, they just ignore you. And then eventually you'd go away. Well, Winston and Fergie decided they were not going to go away. And they kept writing and they were stalled. After 12 months, they sent notice to the Prime Minister that on the 5th of January, 1997, they were going to start broadcasting. And they did. The police went, swooped down on them, took away their equipment, and at that point, we filed a constitutional motion alleging that their freedom of expression had been infringed. To make a long story short, at the Privy Council, after it was denied by the other 2 lower courts, it was decided not only that their rights had been denied, but the Privy Council actually broke with protocol and ordered that they be granted the license. They also quashed the search warrant which had been used to search their premises for irregularity and ordered that the equipment should be restored to them. Now, I'm saying all that to say that this is what I'm referring to when I speak of political capitalism. A system of patronage, a system whereby those who hold office, they procure office, they seek to maintain office, and in doing so, they seek to silence dissent, and they seek to create an environment where only one voice can be heard. Those 3 persons, in those 3 cases, I'm saying that what that represents, it represents a continuum of the discourse of resistance, which started when the first African said no. Now, coming out of all of this, I want to now just spend just a few minutes, time is just about up, on the question of where do we go from here and what's needed at this time. And so I'm looking at how do we interrogate the current system that we refer to as our democratic system in the Caribbean, and I'm referring to Antigua in particular. And I'm saying that any consideration of democratic leadership in contemporary Caribbean life must go beyond the usual managerial competencies. There must be an alignment with the Caribbean people's democratic entitlements. Now, the distinction between a governance system that one would regard as democratic and one that is not is its accountability framework. At least this is one of the main features. Its accountability framework. Now, the executive arm of government must be subject to review by a larger chamber comprising persons representing the wider society. Now, it doesn't matter whether this is a Westminster-style democracy, whether it is an American-style democracy, or whether it is a socialist democracy. whatever you call it, whether you call it the Parliament, the Congress, the Chamber of Deputies, the Chamber of the People's Rights, whatever you call it, in every constitution that uses the adjective democratic, the executive arm of government reports to a larger body which holds it accountable. Now, what we have is the situation in the Caribbean whereby the size in Antigua and Barbuda of the legislative chamber, the lower house of representatives, is 17. Invariably, the cabinet is 9, 10, 11, 12, as many as 14. In that case, the cabinet and the legislative chamber, or the executive arm of government and the legislative arm of government, are practically one and the same. And so because of that, you really have no effective system of accountability. And it is now a matter for the democratic instincts of an individual rather than anything structural in terms of proper checks and balances. And this is an issue that we must address, because whilst we parade and we say, yes, it's a democratic system and it has all the features, in reality, what we are seeing is executive government without any effective checks and balances. Now, this is relevant because when we look at how the history of democratic governance has evolved in the Caribbean, it was called democratic, but it really wasn't. The system was totally authoritarian, just leading up to the period of self-government. The governor general had all the power. He was the president, the prime minister, the leader of the opposition, the director of audit. He was everything. All power was vested in the governor general. And we've seen that tendency towards authoritarianism and that absolutist tendency, which ought to reflect a democratic ethos. In fact, it reflects an ethos which is more reminiscent of the divine right of kings. And that is part of where we need to address problems if we speak of democratic leadership, how we transition out of that. Now, one last point I want to make, it has to do with our size. That the question of these small islands it's almost an absurdity in many ways. But it's something that we need to address with regard to all these small islands which we say we are sovereign. Again, we are sovereign in name. But can you really be sovereign when an investor comes who has more money in his bank account than your entire GDP? How can you be sovereign when you go to the IMF or the World Bank or whomever, and they're in a position to dictate conditionalities which you cannot resist? And so I'm saying that we have to look very seriously at how we reposition the Caribbean so that we do not find ourselves just sovereign in name, but name only. I put in the idea of a confederation of Caribbean states, not a federation, and that's the difference. We tried the federation between 1958 and 1962, and the federation failed. There are lots of lessons that we can learn from that. Today, we have all these sovereign states, and because we have this sovereignty in Jamaica, Antigua, St. Kitts, St. Lucia, etc., it would be a non-starter to tell a king to become a prince or to tell a queen to become a princess. It's not going to happen. But what we can do is find a way to pool our sovereignties. What we can do is find a way so that we speak with one voice beyond what currently obtains in CARICOM. That's the Caribbean Community, and that's mainly an economic union of the islands. We have to design something that is what they would call sui generis, unique, one of a kind, something which is designed by the people of the Caribbean, similar to what the Europeans did with the European Union. They described the arrangement as sui generis, unique. No other body is like that. And that's because it's not exactly a federation like Canada or the United States, where you have one government with several provinces or states. But at the same time, you manage to construct a framework which works for you. And I believe that the Caribbean, I believe we have the talent. We have the talent through our universities, and we can demonstrate that individually, many islands are punching above their weight. Jamaica is punching above its weight in sports. When you look at the Olympics, Jamaica is ranked with China, the USA, and these other big countries. We have the talent. And what we have to look to do at this time is to see how we're going to create this new body that embraces the entire Caribbean. In recent times, the climate change debate, the demand for reparations, the call for reform of the multilateral financial institutions, resisting some of the demands of the OECD countries, all of these would benefit from a stronger voice on the international stage. The OECS, however, I must say, which is the grouping of 6 independent and 3 non-independent countries in the Eastern Caribbean, the OECS has made very significant strides. And we have developed a common currency through the Eastern Caribbean Currency Union, the Eastern Caribbean Supreme Court. We also have a common pharmaceutical procurement service and very effective functional cooperation in areas of health and education. I want to say that the concept of a broader Caribbean federation could be used also as an opportunity to rethink the nature of our Caribbean democracy. The process of constitutional decolonization has taken us thus far. We now have an opportunity to consider new concepts of governance, which are more suited to our size and which are more participatory and inclusive in nature. Remember, colonialism was more than a constitutional construct. It defined the meaning of power, knowledge, law, justice, and human rights. There is a future and an opportunity at this time in our history. We can and we must restructure our social, political, and economic relations so that they are authentically Caribbean, so that they are people-centered and modern at the same time. Thank you very much.